Recording in progress.
Thank you, everyone, for being here. I am Julia Pergola, the Program Officer for DC Refers, and we are thrilled to have James Montana here with us today from the law offices of James Montana. He is one of our panel attorneys. The law office of James Montana is a general practice immigration firm, so they take lots of different kinds of immigration cases. And we are thrilled that he is here with us today and thrilled that he is a member of DC Refers. DC Refers was created to increase access to justice for people of modest means. This means people who make between 200% and 400% of the federal poverty limit. So for a single individual, that is between about $30,000 and $60,000 a year. Lawyers on our panel practice all different kinds of law. And if you're interested in learning more, please check out our website. So without further ado, James, thank you so much for being here. We are thrilled to hear more about current issues in immigration law.
Okay, hi everybody. I have a PowerPoint presentation, and so I'm going to start it. But there are enough people here that I think we probably have lots of questions and lots of perspectives about this sort of thing. So just put the question in the chat. I'll see it. I'll answer it on the way. I'll try to tell a few stories as we go, and hopefully I'll have something to offer. One of those things, hopefully, is the ability to share my screen. Let's see. All right, there we go. So I want to tell you a little bit about our firm. There are 4 lawyers at our firm, and we practice in Falls Church, Virginia. Because immigration law is federal, it is something that you can do no matter what your bar license is. As Julia said, we are a generalist firm. We do everything under the sun, from family-based immigration to asylum applications, both affirmative and defensive. We do a little bit of special immigrant juvenile work. We do business immigration. We do everything except for EB-5s, for those of you who have seen them. Coming up next, I want to make sure that you guys know that I'm not giving anybody legal advice. Most people on this call are lawyers, so you know that I have to do that. I also want to tell you that we're hiring. We are looking for an entry-level attorney here or a mid-career switcher. We offer all the things that you want in a job and none of the things that you don't. So if you know anybody who's interested in, I don't know, low bono immigration work, have them be in touch with me, because I know that we're hiring, and I know that some of the nonprofits in this area that do similar work are hiring also. So I can refer you to places that need good people. The immigration bar is a very friendly bar, and most of the people in it feel that there simply aren't enough immigration lawyers because there is no right to counsel. Many people go unrepresented. And so we would be thrilled if there were more competition. Okay, for those of you who are dipping your toe into the immigration law area, I want to go over a few basic concepts for you. The first is the word visa, which is used all the time, both by clients and lawyers alike, messily. I think people think of visa as a thing that allows you to be in the United States, and that's not true. A visa is a physical object. It's a sticker in your passport. It allows you to enter the United States. So how does this work? As in so many other areas, the US government outsources the hard work to somebody else, in this case, the airlines. So if you have a visa in your passport that says you are allowed to enter, what that operates as is a liability shifting mechanism. If Lufthansa allows you to get on the plane and then you deplane at JFK and the Border Patrol says, no, you may not come in, if Lufthansa let you board without a visa, Lufthansa is on the hook for the return cost of the flight. Untrue if they let you board with a visa. And so the US government sort of deputizes foreign carriers using this system. Visas are always of limited validity because they're just like a hall pass that allows you to enter the country. With limited exceptions, a visa, once you arrive in the United States, doesn't offer you anything else because, again, it is just a way to allow you to board an airplane. Immigration status, by contrast, is not a sticker in your passport. Immigration status is a metaphysical fact. The previous slide said it's like a baptismal certificate, your visa, and status is like baptism. These two slides are taken from my special presentation for Episcopal priests, so that's why the metaphor is there. Immigration status is an extremely broad metaphysical category that includes everybody in this presentation and everybody who isn't. U.S. citizenship is an immigration status, despite the fact that you didn't have to immigrate to get here in many cases. Lawful permanent residency, the fact of having a green card, is a type of immigration status. No status at all is a type of immigration status. Being here as a visitor. All these things are types of immigration status. And the paperwork that people present to you in order to help them with their immigration case, these pieces of paper are stepping stones along the investigatory path to figure out what kind of immigration status somebody might or might not have. A work permit looks like this. If someone approaches you for help, frequently this is something that they're looking for. Work permits are granted to people for all sorts of reasons, including having pending immigration applications in certain contexts. They are always of limited validity, and they are sometimes, but sometimes not, also travel permits. The sample that I've given you here says not valid for re-entry to the US. That means it's not a travel permit. The ones that are travel permits, they don't say is valid for entry to the US, that they say serves as I-512 advanced parole documents, which might as well be in Klingon. But it means that you're allowed to use this card to try to re-enter the US, much in the same way that you would use a visa. Green cards, which are now green again, look like this. A green card is a document that shows that you are a lawful permanent resident of the United States. It allows you to work and it allows you to travel. Now, those travel rights are not unlimited, but for practical purposes, you can take short trips outside the United States without worrying about losing your permanent residency when you return, unless you have a criminal record, in which case life can get very complicated and very expensive very quickly. Because when you attempt to re-enter, they recognize that you're deportable, take away your green card, and place you into immigration court. U.S. citizenship comes in two main flavors, birth in the United States and naturalization. There are other flavors, and I know that there are people on this call who know about them, so feel free to pipe up if you have questions or you want to add another flavor. So how do you become a citizen by birth? Very simple, you're born in the United States or overseas to a military family, or you're born abroad under particular circumstances to a U.S. citizen or two U.S. citizens. Naturalization is quite different. Unless Congress makes you a citizen, in order to naturalize, you have to be a permanent resident. And then after a certain number of years, sometimes 2 years and 9 months, sometimes 4 years and 9 months, you can apply to become a U.S. citizen by naturalization, which requires passing an English test and a history test, and more importantly, paying Uncle Sam $725.00 and sitting for an interview. Just as an interesting trivia fact, only about 1/3 of the people who qualify to become citizens ever do apply and become citizens. The reasons for this are unclear, but my own view is that it's because the process is too complex. The application is 20 pages long. The wait period ranges from 3 months to forever, if you're unlucky. And although the functional requirement that you have to be able to speak English exists in the naturalization process, the level of English that is demanded by the form itself is quite legalistic and quite high. And so people can often benefit, prospective naturalization applicants can often benefit from the service of pro bono counsel and helping them just to get through the 20 pages of legalese that you have to wade through in order to apply to naturalize. We often talk to lawyers and non-lawyers alike who are interested in being helpful to immigrants in their lives, but don't want to practice immigration law for a living. That's okay. And there are lots of ways that you can be helpful. In my view, the biggest way that you can be helpful to somebody who needs immigration advice, but you don't want to provide, is you can help them obtain a copy of their file through the Freedom of Information Act. So FOIA is out there since the 90s, and it is there to help not just US citizens, but also foreign nationals who have encountered the US government in some way. Those ways can include detention at the border, immigration proceedings, applications for green cards, work permits, other benefits, or even an application for a visa. You can turn up these documents via FOIA, and frequently, by obtaining those documents, you can assemble the information that you need for an immigration lawyer to pick up the case and run with it. So you can help people who come into your life simply by helping them to figure out how to help themselves. The Freedom of Information Act will allow you to do this at zero cost by filling out the form G639. Okay. Another thing you can do for people in more dire circumstances is you can help them figure out when they're supposed to go to court. So here's a quick primer on the immigration courts for those of you who haven't encountered this particular flavor of Dante. The immigration courts are a sprawling ALJ-run bureaucracy all over the country. In this area, we have the Hyattsville Immigration Court, we have the Sterling Immigration Court, we have the Annandale Immigration Court, quite new, the Baltimore Immigration Court. So, they're spread out. And in those courts, you defend yourself against charges of removability, deportation, to use the ordinary English word. If you miss your hearing, you're ordered deported. It's a little bit like that scene from Cool Hand Luke, where the warden explains the rules of the prison, that the punishment for every violation of the rules is you spend a night in the box. In immigration court, the punishment for every violation of the rules is a removal order. And so helping people to figure out when they're supposed to go to court is a great way to prevent the most common inadvertent cause of a removal order, which is to say inadvertently not showing up, because immigration court hearings are scheduled sometimes years in advance, changed on short notice. The notification of the change comes via a letter, which may be delivered to a prior address. It's quite easy for people who want to follow the rules to miss a hearing. So what do? Somebody comes to you and says, I'm in immigration court and I don't know what to do. Well, the first thing you should do is you should help them figure out when and where. And there is an automated case information system that you can use to do that. There's an 800 number you can call, but more usefully, if you go to the EOIR, Executive Office for Immigration Review website, to their online portal, and you punch in the A number of the person who's come to you, you can tell them where and when they're supposed to go to court. And they'll even sometimes tell you whether it's supposed to be an in-person or a WebEx hearing. So one useful thing. In even more dire circumstances, someone will come to you and say, my cousin is in detention and I don't know where he is. Just like immigration court, let me give you a quick primer on the detention system. The immigration authorities detain immigrants for various reasons. Sometimes because an immigrant has committed a crime and they've been transported from state custody to immigration custody. More often because they recently entered the United States and they're being detained pending immigration court proceedings. When that happens, they can be detained anywhere the federal government would like, and they can be moved from place to place with relative ease. It is hard to track where somebody is in that system. Fortunately, U.S. Immigration and Customs Enforcement has a detainee locator that you can use to help people find their friends and relatives, which is often the first step to helping them obtain legal counsel, and even ignoring the possibility of obtaining legal counsel. Providing them with contact to their friends and relatives is the good and humane thing to do, even if it doesn't lead to victory in their case. Now, the idea of this presentation is I'm going to tell you the immigration news, so I will. The TLDR here is that the immigration news is mostly good from the perspective of immigrants during the Biden administration, with certain major exceptions. So I'll go over both the good and the bad. Here are some good things that have happened. A lot of TPS has happened under the Biden administration. TPS stands for temporary protected status. Aficionados of the Voltaire quote about the Holy Roman Empire not being Holy Roman or an empire will recognize this figure of speech with TPS, because in practice, it's not very temporary. In practice, it's not very protected. And slide 2 of this presentation about what a status is, it's not a status. But TPS does provide you with a work permit and some security from deportation. The Biden administration has announced TPS for Venezuela, Somalia, Haiti, Ethiopia. They have redesignated TPS for many countries that had it previously. And so people who qualify for TPS from those countries can obtain a work permit and live in relative security in the United States. More good news. DACA continues to exist. It staggers on under litigation threat, which is ongoing out of Judge Hannon's court in Texas. Keeps bouncing up and down from Judge Hannon to the courts of appeals, to the Supreme Court, back down. It is unclear what the eventual result will be. The practice pointer now is that you can't submit an initial DACA application, but you can submit renewal applications for those who still have it. And so that means hundreds of thousands of people are renewing their DACA. The short story on the bad news is that life at the border is chaotic and unhappy, both for people who are approaching the border seeking asylum and for the humanitarian infrastructure on the other side, which is simply not capable of dealing with the number of people who are coming to the United States to seek refuge. In addition to that, I think it's fair to say that the latest round of immigration reform legislation has definitively failed, as did the last 17 rounds before that. And so I think it's disappointing, no matter what your political position is on this issue, that we haven't had a sensible reform. There is this new program, relatively new, called Uniting for Ukraine, which offered a sort of variant of TPS for people who are outside of the United States. TPS typically requires that you be inside the country in order to apply, but if you imagine the perspective of the administration at the beginning of the Ukraine war, there were a lot of Ukrainians who were deeply in need of refuge who were not inside the United States because they simply weren't. The US wanted to offer them a form of temporary protection short of refugee status. And so Uniting for Ukraine was created in order to allow these people to obtain travel permits, enter the United States, and then obtain work permits while they were here. This program worked so well that the Biden administration decided to create similar pathways for certain Latin American countries that send a large number of people to the United States. The idea here is that the Biden administration would simultaneously make it more difficult to cross the border through irregular means and seek asylum, and easier to cross the border through regular means, and thereby decrease the number of dangerous crossings and decrease the sort of the humanitarian load on the border system. At the border, however, the Biden administration has continued to do things that have been a mixed bag, I think, in terms of how well it worked. The Biden administration has greatly expanded the use of something called parole at the border under Section 212(d)(5) of the Immigration and Nationality Act, which allows the president and his administration to admit someone temporarily to the United States for humanitarian reasons. The Biden administration has expanded the use of this provision in order to permit people to enter the United States to apply for asylum, where previous administrations simply did not do this. Instead, humanitarian parole was available with like a 2-inch thick packet of evidence, and it took 18 months to get. Now it's been deployed in a much more systematic way. The Biden administration has reintroduced the much hated Remain in Mexico program from the Trump administration by pushing people towards the use of an app whereby they can schedule a time to attempt to cross the border, the CBP-1 app. You have to wait in Mexico until you're allowed to cross through this app, unless you fall within certain exceptions that are relevant but not possible to talk about during this presentation. Now I want to switch over to some of the more difficult bits of news from the Biden administration. The first and most recent is the enormous fee increases that are coming to the immigration system in about a month. On April the 1st, immigration fees will go up nearly across the board, in some cases in a small way, in some cases hugely. Here's a salient example from our practice. An ordinary green card application based on marriage to a U.S. citizen currently costs $1,760.00. As of April the 1st, the same application is going to cost $3,005. And we expect that that is going to lead to serious hardships for many people. In addition, the Biden administration is imposing what I would describe as supplemental fees on businesses that are seeking to employ foreign workers, like H-1B applicants. Those fees are designed to provide additional funding for the asylum system. In fact, in the new H-1B fee structure, there is a flat fee being added specifically for asylum support. I would not be surprised to see litigation over this provision because it's asking businesses to pay a fee that is not going to go to serve that business in particular. The Supreme Court's recent APA case considers a pretty similar problem where fishermen are being asked to pay the room and board on their ships for regulatory supervision. It wouldn't surprise me if a similar challenge were made here. A bit of good news in this department, the fee increases for naturalization applications have remained relatively small. The most important humanitarian applications, like asylum applications and applications for refugee status, remain zero. And so it is a mixed bag with fees, but it's important to know that ordinary green card applications are going to nearly double in price in about a month. Another bit of bad news, and I don't think that this is an act of intentional policy on the part of the Biden administration, far from it, is that the backlogs in the system are titanic. I realize that I'm being videotaped as I say this, and I don't mind it being replayed. The affirmative asylum application pipeline has about 1 million cases in the backlog, as best we can tell. Affirmative asylum is when you are not facing deportation. Instead, you are asking for asylum, not as a defense, but instead as a way of trying to ensure that your status here persists. Immigration court cases are much worse. We have at least 3 million cases in the backlog in immigration court, and wait times are now measured in years, even for ordinary hearings. There's a great deal of variance here. Locally, we've seen cases move quite quickly through the system in new courts and with new judges because they have much less backlog than the older courts and judges who have been on the bench longer. But it is not uncommon in the immigration system to wait for more than a decade between the day you apply for asylum and the day you receive a final decision. I have several clients like this, and it's becoming increasingly common for people to file writs of mandamus in order to get a federal judge to compel the immigration authorities to issue a decision on the matter. Again, a little bit of good news to sweeten the bad. Naturalization applications are going real quick. Locally, we're seeing them take 3 to 4 months in many cases, or sometimes even less. So those of you who are interested in low bono work may find that naturalization applications offer a pretty quick reward on effort, and making people citizens is just plain fun. So how could you take a low bono case? Well, DC Refers exists, and we'll be happy to refer people who are looking for your help. If you want to take a pro bono case, there are lots of places that will be very happy to connect you with somebody who needs pro bono assistance. To name what, to me, the most salient example, Catholic Charities Immigration Legal Services of the Archdiocese of Washington has an entire team of pro bono attorneys who work to connect you with a pro bono case. They will provide space for you to meet with the client. They will provide malpractice insurance for that case. They will provide a translator, should you need one. They will make it and they will provide mentorship by me or people like me who have practiced immigration law for a long time. Will be happy to talk you through the ins and outs of a particular form of relief. As for what kinds of pro bono cases you can find, the most common ones that are offered are affirmative asylum, which again is when you're applying for asylum from the United States. You are not being threatened with deportation. You will probably be in front of the asylum office in Arlington, Virginia. Defensive asylum cases, where you're being threatened with deportation, you apply for asylum before the courts. VAWA, these are domestic violence cases, typically at the hands of a U.S. citizen or lawful permanent resident. And U visa cases. The U visa is available to victims of crime who cooperate with law enforcement. In case anyone is curious, the wait time to get from when you apply for a U visa to when you actually receive a green card is, by my rough estimate, somewhere between 11 and 15 years at the current time. But by filing now, you can, if you are successful, help somebody to obtain deferred action status, which means a work permit and security from deportation in just a couple of years. So it's very valuable work. Now, I want to make sure that I stop there and start answering questions because there are a lot of ways that you can help in this system, and listening to me talk isn't necessarily one of them. So please ask any questions you've got in the chat, I suppose, or if you want to pipe up. I don't run the meeting, but that's fine with me.
Thank you so much, James. Yeah, so if you have questions, feel free to come off mute and ask them, or ask them in the chat. And we'll give everyone just a couple minutes to do that. If you don't have any questions, let me just say thank you, everyone from DC Refers, and thank you so much, James, for being willing to present to us today. It was interesting and informative, and we appreciate it. So I am going to turn off the recording in case anyone has any questions they want to ask. Thank you so much.